everyone. In the last class, we have discussed about the last portions of the Indian Contract Act, in which we have discussed about the bailment and the bailer responsibility, and we have discussed that how the bailment works when it comes to about the finder of the goods, about the bailer and the bailee, right? So these things we have already discussed in details. Okay. So coming to the point of the finder of the goods, that is explained in section 168 and 169 of the Indian Contract Act, we have discussed that the finder of the goods, the person cannot sue for expenses but can keep the goods until it is compensated, right? That means when there is a thing, for example, I am going on the road, I am getting a golden ring. Okay. That means I am the founder of the goods. I am the finder of the goods. That is the golden ring. I am getting that, right? So when I am the founder of the good of the golden ring, then I don't have a right to get the ownership on that ring because that ring belongs to someone else, right? But yes, I have all right to get compensation or to use the goods as far as I have recovered the expenses that I had bear for that specific ring. Okay. For example, take an example of a specific thing. I am getting something. Uh, for example, there is an instrument. I am getting that instrument on any site or at any specific place. Okay. To take care of that instrument, I am I have expensed up to the amount of 30 to 40,000 of the rupees that has been expensed to recover the instrument up to the original form and to take care of it, right? So when this is the situation that I know that I have to do my specific expenses or I did my expenses to protect that instrument or to save that instrument in a secure manner. For example, there is a small web camera. Okay, that is the secret web camera that I have found on the road. So I collected that camera. To recover the data of the camera, I expensed up to the amount of the 10 to 15,000 of the rupees because I believe that yes, that camera is a very specific camera. It looks like a very micro camera and it might be used by a specific person and that is might be useful for someone. So if I am not recovering the data of the camera, then it will be destroyed. So it is my primary duty to protect and to save the data of the camera and did the same, right? So here, take an example that I have expensed up to the amount of 15,000 of the rupees, right? So here, I don't have a right to claim the ownership on the camera. But yes, I have my right to get compensated up to the expenses up to 15,000 of the rupees that I have expensed for the camera. Because I am the founder of the goods and I have the right to get my compensation that I have expensed for the specific good. And in the other way, if we are looking at some other manner, right? If I want to use the camera, if the person who is the original owner of the camera, if that person is unable to compensate me that specific amount, he can give me the camera and tell me that you just keep it. You use it for the duration of 2 months or 3 months until and unless you are recovering your 15,000 of the rupees that you expensed for the camera. So when my dues are clear, when I have got all my expenses that I have done for the specific purpose of the camera, after getting recovery of my sums, I have my right to give the camera to the original owner itself. So here it is told that a finder cannot sue for the expenses, but he can keep the goods until it is compensated, until he is compensated up to the amount he has expensed for the specific kind of the goods. Then comes the second point. They can sell the good. The founder of the good, the finder of the good, the person, he can sell the good if the first point, the goods may perish or lose the value. The second point, their charge is equal to 2/3 of the value. The first thing, the goods may perish or lose the value. So when we're talking about the losing or perishing of the value of the good, then we have to understand in a different manner. Just let me make you understand that how it works. When I'm talking about that the good will lose its value, it means, for example, that uh, like I have got 3 kg of the vegetables, right? From a specific go down. I got 3 kg of the vegetables and no one is there to claim the ownership on the goods. So I saw that if I am not going to sell the vegetables for a longer time, if I am keeping it in the refrigerator, till when I can keep it? 1 day, 2 day, 3 day? After that the vegetable will be rotten or not? The vegetable will be destroyed, right? So the person who is the original owner, he won't be able to get the benefit from the things, right? So if I am not selling the things, then that is going to lose or perish its value, the dignity, the credentiality of the good, that is going to be down, that is going to be destroyed, right? So when I'm talking about the sale of the goods, then I need to understand that the goods may perish or lose the value if I'm not selling the thing, then this is my primary duty to sell the good at that moment. And secondly, after selling of the goods, the money that I have recovered, after compensating my expenses, I am liable to give the rest of the amount to the original owner itself. For example, to sell the vegetables and to take care of the things, I have expensed up to the amount of 5,000 of the rupees. And from the sale of the vegetable, I got the profit that is up to 10,000 of the rupees. So after recovering my expenses, that was up to the 5,000 of the rupees, the rest 5,000 of the rupees should go to the original owner itself, right? The second point, their charges equal to two-thirds of the value they can sell the goods. Then you can ask me that how does this work, right? So when we're talking about when the charges are equal to two-thirds of the value. For example, the amount of the vegetables that I have got, it is up to the amount of 9,000 of the rupees, okay? And I have expensed up to the amount of 6,000 of the rupees to save the vegetables, to make it reach near the market, to sell it, right? I did all my labor and that is costing up to 6,000 of the rupees. And here the whole amount of the vegetable after selling it, I am just getting only 9,000 of the rupees. So here I have the right to sell the good and recover my compensation. Got it? So here the finder of the good, he can sell the goods if there is two conditions are associated. The primary condition is if the goods may perish or lose the value. And the secondary condition if their charge is equal to two-thirds of the value. Got it? Then comes the Bailey's line, right? This is explained under section 170 and 171 of the Indian Contract Act. So when we're talking about the particular line of the Bailey, it is explained under section 170. And it is explained that a bailee can retain goods until paid for service like tailoring or polishing, right? So when it comes about the retaining goods for, for the paid services, then in that specific circumstances the bailee can retain goods until he is paid for the services. For example, I am going to a tailor, okay? I'm giving my clothes to the tailor to do some stitching works, right? And the tailor started working on my clothes. He did all the stitching was in a very finishing manner. After completing the task, when the person, the person who is the tailor, when he is asking for money, I'm denying him. I'm telling that no, I'm not going to tell you a single penny. So here the tailor has the right to retail the good, and he will say, no sir, if you are not going to pay me the money I deserve for my work, then in the similar manner I am also not going to return you your specific clothes. Yes, the belly can retain the goods until he is paid for the services like tailoring and polishing of the shoes, right? You are going to the person to polish the shoes. If you are not paying the person, if you are telling that no, I am not going to pay you a single penny, you did your work and you have to do it for free. Is it possible? No. When it happens about the polishing works, that person is working for his business, right? So how can you give you the free service? No chance. So he can keep your goods. He said that he will say that no, I am not going to return your shoe until you pay me my expenses. That is how it works. Then only the person will be responsible to pay the specific value that the person deserves. If I am deserving the amount of 50 rupees, then you have to pay me the 50 rupees and you cannot deny to pay me that. Because as the way you are working for your thing, the same way I am working for my own thing to balance my expenses. So if you are not giving me my proper value, then I'll not give you your specific thing that you have given me. I'm not going to give you back your goods until you are going to pay for my service. So when it about the particular line, we have to understand that the belly can retain the goods until paid for services like the tailoring and the policy, right? The second point about the general line. Bankers, lawyers and others can hold the goods for general use until agreed otherwise, right? So particular line exactly indicates to a specific kind of the activity. Like I am polishing my shoe, I am tailoring my clothes, stitching my clothes. So these are the activities in a particular manner. These are the activities in a personal manner where I want to do my works done, right? That is called the particular line. When it comes about a private person, it speaks about the particular line. When it comes about the private life of a person, private need of a person, and private work of a person, then it comes about the particular line. And what is general line? It is explained under section 171 and it speaks about that the bankers, lawyers, and others can hold the goods for general use unless agreed otherwise. The person might be a banker, the person might be a lawyer, or the person might be any other person who can hold the goods for the general use unless agreed otherwise. For the what is the general due? That means, for example, you see that you are putting your money in the bank, right? That is called the general due. The banker is keeping your money safe. You know, locker system where you are putting your ornaments. So you are putting your ornaments in the locker. That is a general due. There is a lawyer who is seizing your thing. For example, I am a lawyer. I am taking advance from you. For example, I am a lawyer and I am taking advance from you. So as a lawyer, you have to give me your general dues. That is called the general due that you are paying me for your uh, service, right? I am seizing some of your property. For example, I'm a lawyer, I'm doing my work for you, and in the course of the cases, you saw that you have to give me certain kind of the things, right? How to say it? See, for example, you are giving me your certain things, like for example you have been detained for murdering someone. So when you are going to the court of law, the court is seizing your property, like your watch, the stick, everything you did or you used to kill the person for which you are accused. The court is seizing everything. So here the court also taking your goods, but in this case also this is a general due because this was needed to do that. It. So when we're talking about the general line under section 171, we need to understand that. When it comes about the general due, the bankers, lawyers and others can hold the goods for the general dues unless it is agreed otherwise. Got it? Next comes section 172, right? So when we're talking about section 172, it speaks about the place rules, right? So coming to the part of the definition under section 172, we have to understand what is a place, who is a punner and who is a punny. The person who who gives the goods as a security for a loan is called the placer. The person who is the receiver of the place is called the punny, and the goods that is given as a security for a loan is called the pledge. So pledge is a good that is been given for the security loan. That the goods that is been given as security for a loan. For example, uh, there is a specific amount of the goods that I require right now, and I have, and the second point is I want to place the goods for the specific purpose of getting loan on something, right? So here the goods that is been given, that is been planned to given for the security for a specific loan or specific activity, that is called the pledge. The person who gives the loan is called, the person who gives the security is called the punny, and the person to whom the place is been given or who gives the money is called punny, right? So when we're talking about section 172, we need to understand these things. The first thing is the punner. The person who is the pleasure is called the punner. The second point, we speak about the punny, who is called the receiver of the place. Then the third one is the the first one is the punner, the second one is the punny, and the third one is the pledge, right? So then comes section 173, under which we are going to discuss the rights of a punner. So what are the basic rights of a punner? The first right, it speaks about the retaining goods for loan, interest and expenses. The second point, selling the goods after the notice if the pawners defaults, right? Then the third point, it speaks about any extra money from the sale that goes to the punner, any extra money from the sale that goes to the punner, right? And when it comes about number 10, it speaks about a punner can reclaim goods before the sale by paying the loan and the expenses. Got it? So this is explained under section 177, which speaks about the punner's right to redeem the thing. The first thing under section 173 to 177 we have discussed, the punner has the right to retain the goods for the loan, interest or expenses. The loan, the interest or the expenses that can be retained by the punny. The pawnee is who has given, who has been given the uh, specific thing, or who has given the loan, right? So when the pawnee, or the person who has received the value, who has given the money, if he observes that the person who is the pawner, he is not paying on a very particular timing, then the pawnee has the right to retain the goods for a loan, interest, and expenses. Got it? So in this situation, when we are talking about the retaining of the goods, this is the right of the pawnee to retain goods for a loan, interest, and when we are talking about the selling of the goods, the pawnee has the right to sell the goods after the notice if pawner the default. The first thing is like, if for example I have given you my golden ring that is up to the amount of 70,000 of the rupees, and I have taken from you up to the amount of 20,000 as debt, right? So when you are unable to pay me back the specific goods, then I have the right to ask you to retain the goods from loan, interest, or expenses. I'll ask you to retain your good from specific place or expressions, right? So when we're talking about the second point, it speaks about the selling of the good after notice if the pawner defaults. For example, I have got this like, this is my golden ring. So there is a person who is the pawnee, right? So I have given this ring to the pawnee as a part of the place, right? So when I have given the thing, my ring to the pawnee as a part of the pledge, then I have then I have observed that the person who is the pawner who has given me the specific ring, that person is unavailable, that person is not coming back, and I can clearly see that there is no far vision that that person is coming back and paying me my money. I can see that clearly, that person is not coming back to pay me my money. So in that specific circumstances, I have all the rights to sell the goods after notice if the pawner defaults. I have the right to sell the goods because I have given you the notice, but you are not fulfilling your duty. You are not paying me money on time. So I have the right to sell the goods that you have given to me in exchange of the debt. The third point, it speaks about the any extra money from the sale which goes to the pawner. Okay. So on the third point we discussed, he is entered the pawner's right to, it is the right of the pawnee to get any extra money from the sale that goes to the pawner. Okay. For example, after recovering the after recovering the all the amounts that pawnee has pawnee was supposed to get, it is the right of the pawnee to send back the remaining money to the pawner itself. Okay. So next we have discussed about the pawner's right to redeem, that is explained under section 177, and it has been told here that a pawner can reclaim the goods before the sale by paying the loan and expenses. Got it? What does it mean? A pawner can reclaim the goods before the sale by paying the loan and expenses. Okay. So the person who is the pawner, who has given his own goods as a as place, right? Before the completion of the time, for example, there is a time period that in between the duration of 2 months, the debt was supposed to be recovered. and the debt is not getting recovered in the duration of the 2 months, the property that belongs to the Pani, that will be recovered. The property that has been given to the Pani, that will be recovered. It is the mutual condition, mutual agreement between the Panner and Pani that has been done before. So if the Panner wants to save his property from being sold or going to the Pani completely, he has the right to save his own property by paying the amount. For example, the loan amount was 15,000 of the rupees. Then it is the duty of the pawnee to pay the specific amount before the completion of the time. Got it? So when we're talking about the pawner's right to redeem, the pawnee can reclaim the goods. The pawnee can reclaim the goods before the sale by paying the loan or expenses, and that repayment of the loan and expenses makes free the pawnee from the liability of the place, and it is explained under section 177 of the Indian Contract Act, right? Then we are going to discuss the last part, that is about section 178 to 179, and it speaks about the special place rules. And special place rules speaks about one special thing. What is it? The agents or those with limited rights can place the goods if they're acting in good faith. For example, I am your agent or I am working for you. We have already discussed the concept of the agency, under which we have already discussed that what is the agent, right? So the person who is an agent, or the person who is an agent who has the limited rights, the person can place the goods if they are acting in good faith. Okay, for example, I am working as your agent, or you have appointed me as your agent. So when I am acting as good faith for you, that when you have a very good bond for me, you have given me all your freedom, that yes, go. Whatever course of business you feel that is essential to do, do that. I have got that right to do by you as your agent. So I can and I have the right to place the goods if I am acting in a good faith for you. You are my master. You are my owner. I am your agent. I am acting in good faith for you. So, as an your agent, I have all my responsibility to take care of the business, and during the course of business, I got to find that yes, this is my responsibility right now to place the goods, because I need the debt immediate basis. I need 2 lakh of the rupees on an immediate basis. I have to collect it anyhow because my master is not present at this moment, and I have to handle the course of business right now. I don't have any other option. So what I have to do? I have my only way that time, that I have to place the goods to collect the money, and then I can just pay it back through other sources, right? So when we're talking about the agents or those who is been appointed by the owner, who is having the limited right, they can place the goods. I can place the goods of my owner or the goods of the company if I am acting in good faith for my master. If my activities are pure, if I am acting in good faith for my owner, then comes the last part, that explains about under section 180 and 181 of the Indian Contract Act, and it speaks about the suits against the wrongdoers. So who is a wrongdoer and how the suit against the wrongdoer it works? Okay, so it speaks that if a third party damages or takes the goods, both bailor and bailee can sue. Compensation will be shared based on their interest. Okay, so let me explain it that how it works actually. Okay, for example, uh, just take an example of anything like you have there is a bailment There is a, for example, there is a watch of mine, okay? So I have bailed you that specific watch, okay, for the purpose of repairing it. So I am the bailor over here and you are the bailee. I am the bailor who has given my watch to you and you are the bailee who has received the watch from me, right? So there is a third person, okay, who entered to your shop. Before you repair my watch, he took my watch from you. He has stolen my watch from you. So here there is a damage to both of the party, because as a bailor you are suffering the loss and as a bailee I am also suffering the loss, because this is the mutual loss. You have taken all your proper care, but even after that you couldn't save my watch. And I was supposed to take care of the thing. I was also careful to protect my thing, but I couldn't take care of the thing. So it has been stolen, right? So when we see that, even after taking all the proper cares and the caution, the thing has been stolen. And a third party who causes the damages to the goods, and both the bailor and bailee can sue the third party for the damages. And for example, the person who had stolen the watch, if he has been caught, he has to pay the compensation, right? For example, the price of the watch is up to 10,000 of the rupees. So here he is supposed to pay the compensation amount of the stolen goods, right? He has to pay for the he has to compensate for the thing he did the stealing of the activity he did. He has to compensate for that, and that is mandatory. You know that, right? So after getting the compensation, it will be shared between the bailor and the bailee as per their interest, right? For example, I have repaired your watch, and to do the repairing stop, I have expensed up to 2,000 of the rupees. So if I am getting 10,000 of the rupees from as a compensation amount, I will get the 2,000 of the rupees, and the actual cost of the watch, that is 8,000 of the rupees, that will go to the bailor. So here it is clearly said that when there is a third party damages or takes the goods, then in that specific circumstances, both the bailor and the bailee can sue for it. And the compensation, whatever it will be received, it will be shared on the interest basis of the parties. The interest of the bailor and the bailee, that will be divided, and according to the ratio of their interest, the amount of the compensation will be divided, will be distributed on that. Got it? So this was about the section 180 and 181 of the Indian Contract Act, right? So coming to the flashback, we are checking that we have almost covered the all portions of the bailment and the bailor and the bailee. Yeah. And this is how the concept of the bailment, bailor and the bailee has been completed. And then comes the chapter of the agency at chapter 8, chapter 10, that we have already discussed, that who is the agent, what are the duties and responsibilities of the agent, that we have discussed. And then we have also discussed the last chapter that has dealt about the agency only. Just one second. Having a small flashback on all the chapters of the Indian Contract Act, also we have discussed about the last chapter that speaks about the partnership, right? Yeah. And the chapter of the partnership, that has been already repealed, okay? Unfortunately, it is no more in the Indian Contract Act anymore. So, there are around 11 chapters that was prior, but now it is 10 chapters of the Indian Contract Act, and I think we have already covered all the chapters, right? Like we have already completed the first chapter that speaks about the communication, acceptance, and revocation of the proposal. Then in chapter 2, we have discussed about the then in the chapter 2, we have discussed about the voidable and the void agreements and the contracts. Then in the chapter 3, we discussed about the contingent contract. In the chapter 4, we discussed about the performance of the contract. In 5, we discussed about the relations resembling those created by the contract. And chapter 6, consequences of the breach of the contract. Chapter 7, we discussed about the sales of the goods. Then in chapter 8, we discussed about the indemnity and the guarantee. Chapter 9, we discussed about the bailment. Chapter 10, we discussed about the agency. And chapter 11, we discussed about the partnership. Partnership has been unfortunately removed, so that is no more in there. Okay, the sales of the goods also has been removed from the Indian Contract Act, and I think we have almost covered all the chapters that is needed in the Indian Contract Act. Okay, so this was all about the Contract Act. I think we have. I told you wrong. Like there are the 11 chapters, but now it is 9 chapters in the Indian Contract Act because the sales of the goods and the last one, like the partnership, that has already been removed through the other different laws. That is the Sales of the Goods Act, and there is the Partnership Act. That has been separated now. So rest all 9 chapters we have discussed in a full-fledged manner. So this is all about the Contract Act. We can just conclude it here. And next we are going to start with some new concept over there. This is all for today, guys. Thank you. Bye bye. Take care.